Chuck, I only see 6 participants. Is that the way it's going to be, or?
No, I'm just about to push the button. So
okay.
Consider yourself on. Are you ready?
We were born ready.
All right, here you go.
Okay. Well, welcome all. Welcome to our first membership meeting since January. I see following the tradition of MIAS, people are here early. It's 8 o'clock in the morning here in Miami, but we make that precision because there are people from on the other side of the world, from Singapore, joining. So thank you all for joining, being so punctual. This is an exciting meeting for many reasons. We are going to later on during the general presentation of the membership meeting, we're going to be unveiling our new website, where we're going to show how MIAS is going to be promoting our members. And hopefully you will all be excited to see that. We will have the return of the Rooney report. I see John Rooney here up and early. Thank you, John, and several of you. But we really have, and we're going to kind of invert the order this time, because we have guests literally from across the world. We're having a presentation by the Singapore International Arbitration Center, SIAC. And I believe they're going to talk about their efforts in the Americas. We are incredibly fortunate to have someone who actually needs no introduction, Gary Bourne, who is the president of the SIAC Court of Arbitration. Everyone understands he is the head of Wilmer Cutler's arbitration practice, and most of us have the Bible that he wrote in 3 volumes here on our shelves. So thank you, Mr. Bourne, for joining us. We also have SIAC's Chief Executive Officer, Ms. Lim Siak-Hu, and Adriana Usan, who's heading up SIAC for the Americas. Before I make any further mistakes, I'm going to turn it over to Gary. Again, Gary, thank you so much for joining us, and I give you the floor. By the way, I do want to mention to everyone that this membership meeting, as all membership meetings going forward, is being recorded. So I can't, we can't have Chatham House rule applied because it's going to be repeated. So understand that. With that, Gary, please take the floor.
Thank you, Louis. Thanks so much for both giving me the floor, if only virtually, together with Siak-Hui Lim and Adriana. We also want to thank everyone at MIAS and all of our friends. I see lots of familiar faces there, even if just thumbnails on the screen. At SIAC, we appreciate the opportunity to be able to introduce ourselves again, if only virtually, to what's, I think, known around the world as a very vibrant, exciting center for international arbitration, not just in Latin America or with the Americas, but internationally. And I think in that regard, there are a lot of similarities, a lot of synergies between Miami on the one hand and Singapore on the other. It's also a very timely occasion for us to present to you, to talk with you, and we'll be happy to answer questions after the presentations are concluded. It's timely because, as I think has been whispered in the hallways or talked about on blogs and so forth. There's been a lot of news about the possibility or likelihood of SIAC opening an office in the United States. And if we were to do so, obviously, international arbitration involving Latin America, involving Miami would be a key part of our efforts. And so, although the pandemic has slowed down or changed lots of plans, I do think this is a very timely moment. Perhaps more on that in Q&A. For some of you, though, SIAC may be an unknown quantity or just a set of initials that one hasn't come across that frequently yet in practice. It's in part it's because SIAC is comparatively a relatively young, relatively vigorous, therefore, institution. We'll celebrate our 30th anniversary next year. We were founded in 1991 and began, unsurprisingly, with a somewhat unimpressive caseload. I think in our first 2 or 3 years of existence, we had 2 or 3 cases. That's all been dramatically changed, in particular over the last 5 years or so. Our caseload last year was around 480 cases registered with new filings, registered with SIAC, and obviously a very significant pending caseload, cases filed in earlier years. One sometimes wonders what the pandemic will do to arbitration, to dispute resolution generally. The good news, at least from SIAC's perspective, is that this year has been by far the most robust year in terms of caseload, case filings, number of proceedings. In our history, we will very significantly exceed last year's figures, and I suspect we will be nipping at the heels or potentially ahead of our historic main competitor, the ICC, the International Chamber of Commerce. In part, that's because SIAC, notwithstanding being headquartered in Singapore, is not an East Asian, is not an Asian arbitral institution. We like to think we know more about arbitrations seated in that part of the world with some of the legal particularities and peculiarities that region carries with it. But we conduct at this point arbitrations all over the world involving parties from all over the world, and perhaps surprisingly for some of you, in particular involving the United States. The United States has been, US parties have been among our top 3 users consistently over the last 5 years or so, and we would, given the importance of US businesses internationally, expect that trend to continue very significantly. And that's particularly true if we establish a US presence in the coming months, as I alluded to previously. Historically, our largest users, you can see some of the statistics on the current slide, have come from India, the United States, China, elsewhere in Europe, elsewhere in the region. There are a variety of reasons for both the international reach, the global reach of SIAC on the one hand, and also for the substantially increasing caseload that I alluded to previously. I like to group them into 3 main categories. It's on the one hand, the legal framework, then secondly, the institutional arbitration rules at SIAC, and then finally, the people at SIAC. Let me say just very briefly a few words about each one of those 3 categories. Singapore has been, for a couple decades now, powerfully committed to arbitration, to international arbitration in particular. Naturally, a party to the New York Convention, also an early adopter of the UNCITRAL model on international commercial arbitration, with some recent tweaks to bring it to state of the art, tweaks with respect to things like emergency arbitration, confidentiality, and the like. Singapore has a very pro-arbitration judiciary. The Chief Justice in Singapore, Sundaresh Menon, is a former international arbitration practitioner. I'm not sure there's anyone on from Jones Day, but he, I think, co-headed their international arbitration group for some years before going onto the bench, and he has a keen interest in and knowledge of international arbitration, especially international commercial arbitration. The Singapore Court of Appeal has issued a number of robustly pro-arbitration rulings over the past 5 years, past 10 years or so. And as a consequence, seating an arbitration in Singapore ensures a very hospitable, a very stable and secure arbitral seat. Singapore doesn't face the sort of political uncertainties that one often sees in East Asia, particularly in some of the jurisdictions that have historically been regarded as alternative or substitute arbitral seats. Singapore has a long tradition of security and legal stability. That's why businesses choose both to base their operations in Singapore for Asia, but also why parties choose to arbitrate in Singapore. Of course, though, if you choose the SIAC rules, which is my second category of features about SIAC, you can seat your arbitration anywhere. You don't need to seat it in Singapore. You can seat it in Miami. You can seat it in New York. You can seat it in any jurisdiction that you choose. Singapore is a great place to seat an arbitration. It's much less inconvenient these days, where Zoom calls like this and virtual hearings free us in Singapore, but also other places, from the tyranny of geography. You don't have to get on planes quite as much as one did previously, and who knows how long that is going to continue. The SIAC rules, I think, are state of the art. We revise them every 3 or 4 years. We're incidentally in the midst of a rules revision consultation process just at the moment. Our last revision was in 2016, but we want to ensure that we're not just keeping pace with the ICC and our competitors, but in fact being thought leaders and pushing the envelope in terms of provisions for efficiency and expedition in arbitration. I'll say a few more words about that in just a moment. The SIAC rules are based largely on the UNCITRAL rules, but with some very important tweaks. Those additions, those amendments to the UNCITRAL rules include things like expedited procedures, emergency arbitration, early dismissal, and consolidation, joinder, multi-contract provisions, and a word just about each one of those various things. We introduced the concept of expedited procedure several years ago, 5-6 years ago, and have had more than 400, I think more than 500 at this point, expedited procedure applications, a substantial number of which have been granted. Under the expedited procedure rules, if a case is small value, currently defined as less than 6 million Singaporean dollars, that's roughly $4.5 million US dollars, or if it's a case of exceptional urgency, and the emphasis there really is on exceptional, or if the parties so agree, they consent either in their arbitration agreement or after the fact, then the SIAC Court of Arbitration has the power, it's not the obligation, but the power to put the case into an expedited procedure. If a case is expedited procedure, then the arbitral tribunal is obliged to make its award 6 months from constitution of the tribunal. There is an out, a safety net, so to speak, whereby if the tribunal concludes that either because of new developments or because the case was more complex than anyone had realized at the outset, or perhaps larger than had been indicated to the institution, it can request that the case be unexpedited, i.e. have the 6-month time limit lifted. that occurs relatively infrequently, but if it transpires that a case, although it looked like it was appropriate for expedition, in fact isn't, then one can put it back on, so to speak, a normal track. The institution, the SIAC Court of Arbitration, has the authority to appoint a sole arbitrator in expedited procedure cases. That's often necessary in order to meet the 6-month timetable. And the arbitral tribunal has broad authority with respect to the conduct of the proceedings and to the making of the award. The parties can agree that the award can be in summary form, only summarizing the reasons, not having the more detailed award that one sometimes sees in international investment arbitration and other arbitrations, other commercial arbitrations. Users have been overwhelmingly positive about the EP mechanism, the expedited procedure mechanism. We, during our last rules revision, consulted as to whether parties thought it trenched upon their due process rights or whether the monetary limits were too high or too low. And almost unanimously, commercial parties in particular said that they wanted more expedited procedures, not less. In the same vein, we introduced in our last rules revision an early dismissal mechanism. In a sense, the name is a little misleading because unlike ICSID's early dismissal mechanism, which needs to be invoked 45 days after constitution of the tribunal, our early dismissal mechanism can be invoked at any point during the arbitration. So in a sense, it can be a late dismissal. The basic concept of an early dismissal or late dismissal, however you want to phrase it, is that a party can apply to the tribunal to have a claim or a defense dismissed because it's manifestly without legal basis, or alternatively manifestly outside the tribunal's jurisdiction. It's a little bit like a motion to dismiss for failure to state a claim, or for lack of jurisdiction in US procedural terms. The basic notion is that one oughtn't to have to go to a final hearing, one oughtn't to have to go through the time that even an expedited arbitration might take if there's plainly no legal basis for the claim. And the emphasis there is very much on the manifest requirement. This is a mechanism a tribunal can use to weed out essentially frivolous or entirely meritless claims, or alternatively defenses. The early dismissal mechanism has been used a number of times since we introduced it 4 years ago or so. It's in the hands of the arbitral tribunal, of course, but a number of arbitral tribunals, a couple dozen at this point, have both considered early dismissal applications and in a substantial number of cases granted them. We also have an emergency arbitration mechanism whereby emergency arbitrators can be appointed at the request of one party, typically the claimant, when an arbitration is commenced. Like other EA mechanisms, the emergency arbitrator is appointed quite quickly. We think more quickly than at other institutions. In our case, always in less than 1 day, 1 calendar day, with an obligation for an initial procedural meeting with the parties. In these days of Zoom meetings, it's easier than otherwise, in 3 days, and some sort of decision within 10 days. Substantial number of EA proceedings going on even at the moment. And over the last 5 or 6 years or so, there have been more than 100 EA applications, and in a substantial number of cases, some sort of interim relief has been granted. The interim relief that the emergency arbitrator grants is, of course, truly interim. It's only valid for either 90 days or until the real arbitral tribunal is constituted, whichever comes earlier. The real arbitral tribunal has full authority, of course, to either modify, vacate, or maintain whatever emergency interim relief the emergency arbitrator granted in the first instance. One of the things that we take very seriously, perhaps more seriously than anything else at SIAC, is appointing the highest quality arbitrators. We think it's important in this regard, in contrast to some of our competitors, the ICC in particular, be transparent about the mechanisms for appointment of arbitrators. We list a panel of arbitrators on our website if any of you are interested, particularly given our increased focus on the Americas and applying to be on the panel. We strongly encourage you to do so. But parties can see the types of people that we will appoint as arbitrators on our website. The SIAC court, comprised of 35 members from around the world, is responsible for selecting arbitrators. We don't go to national committees or other committees whose composition or even identity you might not know at the outset or frankly ever know. Instead, the SIAC court, again, whose members are on our website, is who makes that decision. And we make the decision quite promptly. We don't bounce things back and forth between committees. It's a prompt decision in order to ensure that arbitral proceedings, once started, proceed in an expeditious fashion. One of the innovations that I adopted as president as well was when I appoint arbitrators, I don't just send them a letter of appointment notifying them that they've been mandated to serve as an arbitrator in a particular case. I also send them a letter in a sense of warning, a letter emphasizing, underscoring the importance of expedition and efficiency to SIAC, and observing correctly that the registrar will be observing the proceedings with respect to the timeline. Obviously, the arbitral tribunal has full discretion to decide the substance of the case, but we'll be observing the timeline to ensure that it is carried out consistently with the parties' expectations and the usual time that it takes for dispute resolution in matters of that nature. If cases lag, and inevitably with a caseload the size of ours, cases do occasionally lag. Not every tribunal is perfect, not in any institution. Both the registrar and I will take appropriate measures to ensure that the tribunal is reminded of its obligations of expedition. We also scrutinize awards, unlike some of our competitors, the LCIA, for example. But we ensure that the scrutiny process is conducted quite expeditiously. Some institutions, I know because I spend a lot of time as counsel, and some institutions take a fair number of weeks, sometimes even months, to scrutinize awards. And you're never entirely sure when a tribunal has finished its deliberations and drafting of an award and submitted it to the institution. We, in contrast, aim to ensure that scrutiny is completed within 3 weeks, and typically it's completed in a good deal less than that amount of time, and that the parties are fully apprised of the status of both the deliberations and the award. I know that commercial parties in particular like to know where their case stands when it's been taken out of counsel's hands and put into the tribunal and the institution's hands. We've had an excellent track record of recognition and enforcement of our awards, both in the Americas, in Europe, and in Asia. Some Asian jurisdictions, I think in particular of Indonesia, have a number of local peculiarities with respect to recognition and enforcement. And given the nature of our caseload historically, we're very familiar with those formal requirements, other requirements, and do our utmost to ensure that awards will be recognized efficiently and effectively in all the jurisdictions in the region and elsewhere. Finally, just a word about people, and I'll let then SIAC and Adriana say a bit more about the people. We have a board at SIAC. You can see it on the current slide. It's chaired by Devinder Singh, one of the leading litigation lawyers, not just in Singapore, but in Asia. And a number of other distinguished practitioners, both from Singapore, but also around the world. Our Court of Arbitration, 35 or so members, you can see it on the next slide, comprised of practitioners from all over the world, not just Asia, not just Europe, but the United States, elsewhere in the world. I do think it draws the very best arbitration talent from every generation, from from every region in the world. I want to conclude, though, by focusing on the registrar's office, where Delphine Ho is our registrar, Kevin Nash is our deputy registrar, both of them with very substantial experience in case administration. Fluency in the registrar's office with all languages. We can conduct arbitrations in Spanish as well as English, as well as a number of other languages, both European, Asian, and otherwise. This is, I believe, a particularly timely moment, given the amount of Asian investment in Latin America, the cross-border trade between the United States and Asia, to think about SIAC. It is a truly neutral jurisdiction in many ways. If you've had the opportunity to walk around the streets in Singapore, it looks a lot like either Miami or California, certainly more so than somewhere like Paris or Geneva or Zurich does. It's a place that is characterized by legal stability and pursuit of excellence as well as diversity. And I think it's a place where increasingly parties, when they have contracts that have nothing to do with Asia or Singapore, contracts between Latin America and Europe, between North America and Latin America, will look to Singapore, will look to SIAC as the most expert, the most efficient way of resolving their commercial disputes. But with that, perhaps overly long introduction, perhaps Siakwi and Adriana can elaborate on some of the more important points that I've lost in the forest.
Thanks, Gary. I think you've just about covered everything, which leaves me not really that much to add or to say, but I would, just following on from what you said about SIAC and it being a global institution and its popularity because of neutrality, efficiency, integrity, and political stability. I mean, these days, over 80% of our cases are international, and over half of them have no connection whatsoever to Singapore. So we could have US parties with parties from anywhere else in the world. And you can see on the current slide, which we had earlier, that the top 10 foreign users come from a mix of civil and common law jurisdictions. In the last 5 years, again, on that point, we've had parties from over 100 jurisdictions, which goes again to our neutrality. And in the Queen Mary and White and Case survey, Singapore is ranked the third most popular seat in the world, and SIAC the third most preferred arbitral institution in the world, which makes us the most preferred institution in Asia, and Singapore the most popular Asian seat. In terms of the people, and Gary's covered that as well, we have a board of directors chaired by Davinder Singh, a top litigator, who's a household name in Singapore and in Asia. And then the board members are a mix of arbitration as well as corporate experts. The Court of Arbitration is 32 members strong, with Gary as its president and 2 vice presidents, and again, a mix of civil and common law jurisdictions. My role as general dog's body is to do whatever Davinder, the chairman, and Gary as president tell me to do. I also oversee business development, and we have various overseas offices in India, in China, in Seoul, and that covers both Japan as well as Korea. And as Gary alluded to, very soon we hope to have a presence in the US. Our secretariat mirrors sort of the multinational mix, the multinational composition of the Court of Arbitration. It is made up of a team of lawyers, not just from Asia, but also further afield. And they are qualified in various jurisdictions, including the US, Canada, as well as closer to home within Asia, obviously from Singapore, Malaysia as well, India, China, the Philippines, Indonesia, and elsewhere. As Gary mentioned, we are able to administer language arbitrations in languages other than English. We've done bilingual arbitrations in English and Chinese, in Vietnamese, in French, as well as other languages. I think I will touch a little bit about COVID and what we've been doing. As the initial pandemic measures are gradually eased over here in Singapore, our office, our physical office, has gradually been reopening in stages. So now we are currently open 3 days a week, although most of our staff are still telecommuting and working from home is pretty much the new normal. However, as staying connected is truly important to us, we have done so through webinars, through online training programs, as well as a live chat feature on our website. So you can chat to any member of the Secretariat or somebody from SIAC during normal business hours here and have your questions answered in real time. We've also, because virtual hearings is very much part of the new normal these days, also released recently the first of the SIAC guides, a checklist essentially of do's and don'ts and how-tos for arbitration users that are less familiar or unfamiliar with remote hearings. So this is just a broad snapshot of what we've been doing during COVID. We are busier than ever. In fact, we've registered a very strong caseload growth this year during the COVID pandemic, and emergency arbitrations particularly. We've had 109 of those to date since this was introduced in 2010. Gary covered this earlier, and it's been extremely popular. This year alone, we've had 15 emergency arbitration cases, 11 of which came in during the COVID months from April to October. So the hearings were all done virtually, and the order was issued on time within the time frame set by the rules of 14 days. I don't think I've very much to add. I don't know if Adriana wanted to chime in at this point. Adriana?
Thank you, Sakui. So maybe I'll pick up on the emergency arbitration point. Most of the time and cost saving mechanisms have been discussed earlier by Gary, but I just wanted to address probably a question that Americans or Latin American party might have on our emergency arbitration procedure, which is, how useful is this mechanism to us given the time difference in Singapore? And having been previously counsel myself at the SIAC Secretariat, I can attest that time zones do not necessarily apply to us, especially when it comes to emergency arbitrations. Our Secretariat effectively works around the clock. Our President, Gary, who decides the application and appoints the emergency arbitrator, sits in London. Our Vice Presidents are based in Singapore and New York. And with all these time zones covered, if you need to have an emergency arbitrator at, say, 1 p.m. Eastern Time, SIAC can still get that done. And this is part of the reason why we are receiving applications from all over the world, including North America, Europe, and Africa. And the other part, of course, is that very few courts are open and ready for business like SIAC is in the very late evening. Being the first institution in Asia to introduce this provision some 10 years ago, we also have the advantage of experience. As Sokwi just mentioned, we received 109 applications in total, and our tried and tested case management techniques enable us to put in place and give effect to some of the fastest timelines in the world. Gary has touched on expedited procedure, early dismissal, and maybe I can say a few words on consolidation and joinder. So we have a multi-contract consolidation and joinder provisions, which all serve to save time and cost by streamlining the proceedings. Under our multi-contract provisions, a claimant only needs to file a single notice of arbitration for disputes arising out of multiple contracts. In this scenario, the claimant would be deemed to have commenced multiple arbitrations, one for each arbitration agreement, and the notice of arbitration would be treated as an application for consolidation. Alternatively, a claimant can file multiple notices of arbitration and concurrently submit an application to consolidate. One particular advantage of this provision is that we allow the payment of a single filing fee of about $1,500 US and payment of a deposit of less than $3,000, no matter the quantum of the claim, until, of course, our court determines the consolidation application. Under our consolidation provision, 2 or more arbitrations can be consolidated into a single arbitration if the parties agree the dispute arises out of the same arbitration agreement or different but compatible arbitration agreements. So we don't need complete identity of the parties like in other institutions, which is a distinct advantage in multi-party disputes. Another important distinction is that our rules allow the consolidation application to be made before the tribunal is constituted through the SIAC court or after constitution through the tribunal directly. One advantage of pre-constitution application is that all parties will have the opportunity to participate in the appointment of the arbitrator. A similar approach has been taken in our joinder provisions, which are designed very broadly and could allow both a non-party and a non-signatory to be joined if the parties agree or they are prima facie bound by the arbitration agreement. The application may be made also either prior to the appointment of an arbitrator, in which case the application will be made to the SIAC court, or after the constitution of the tribunal. And so if the application for joinder is made prior to the appointment of the arbitrator, again, the joint party may participate in the appointment of the arbitrator. Finally, we also offer a unique service that combines the use of mediation and arbitration. We teamed up with the Singapore International Mediation Center to create what we call an ArbMed-Arb protocol. This is a one-stop process where a dispute is first referred to arbitration, which is particularly helpful if there is a limitation period. Once the tribunal is constituted, the case is referred to mediation with the Singapore International Mediation Center. If the mediation results in a settlement, the parties may go back to arbitration and have a consent arbitral award issued on the terms agreed at the mediation. And as you know, this consent arbitral award will have the benefit of enforceability under the New York Convention. Now, if mediation is unsuccessful, parties may go back to their already constituted arbitral tribunal and proceed with the arbitration. I would say these time and cost saving mechanisms have been effective. SIAC's cost and duration study shows that cases before a sole arbitrator takes less than 1 year to complete, and cases before a 3-member tribunal take around 14 months. But of course, we are always striving to improve, and we constantly look to implement user feedback to see how we can make our arbitrations even more efficient. And that's a brief insight to SIAC. We want to thank Luis and Dan for arranging this and for having us. We're happy to take questions.
Thank you so much, Adriana, Gary, SIAC. Can you take away the sharing screen so that we can see the whole, now that we're going to go to the question and answer. First off, I want to thank you all. And the success of SIAC is not surprising, certainly to those of us at MIAS. I remember when Inez, Dan, I went to Singapore in 2012 for the ICA Congress, and you were very helpful to MIAS as we prepared for our Congress 2 years later in 2014. And your professionalism and really the entire, and Singapore is just an amazing city. It was really quite impactful to me to see that. And just, I remember looking out of the Marina Bay Sands and looking at and seeing all the container ships just littered across the bay. And I had never seen that kind of maritime traffic. And it really showed how vibrant Singapore is. So again, thank you so much. I want to open it up to the floor for questions. If anyone from the members would like to have the opportunity to ask questions, this is your time.
Hey, this is Dan, Gary, SIAC, and thank you so much for the presentation, which was extremely thorough. Maybe perhaps one thing, because I know we chatted a little bit about this, and you all mentioned that you're looking to grow your presence in the Americas. Perhaps you could tell us a little bit about what those plans are as they've been developing. In particular, do you see some of the administration functions that you have for some of the caseloads being administered from the U.S.? What do you think that's going to look like going forward?
Yeah, perhaps I'll handle that one. Thanks very much, Dan, and also thank you, Dan, for the previous advice counsel that you gave SIAC and Adriana and myself about U.S. and also possibilities.
Papá,
naturally, with
¿huele
any,
quemado?
Ya no huele, ya se desquemó.
Sí, digo, me-
We have somebody needs to mute.
Yes, can anyone that's not speaking, please put their thing on mute. Gary, please. No, you're now, Gary, now you're on mute.
I don't know how that happened. Okay. So like any institution, SIAC, before it does something big, begins to go quiet about things. You could imagine, though, that if we were to open a U.S. office, it very likely would be in New York. It very likely would be focused both on U.S. companies, but also with of critical importance, Latin America and Latin American companies. We'd be looking to recruit fluent Spanish speakers, either as the head or reporting to Adriana, the deputy head of U.S. operations. We'd be looking to reach out to international law firms, but also local practitioners in key centers in the U.S., Miami, San Francisco, Chicago, Houston, as well as New York. And we'd be looking to draw on your contacts. At the end of the day, the way that we as an institution succeed is by persuading you, by persuading people like you and your clients ultimately to put SIAC clauses into their contracts or to recommend SIAC to their clients. That's part of the reason that when we revise our rules, we have a much more public and extensive consultation process than I think other institutions do. It's part of the reason that we spend a lot of time reaching out, both individually, but also in groups like this to US practitioners and to be fair, practitioners in other jurisdictions. We have folks with a lot of Latin American experience on our Court of Arbitration. I think you've seen that from the slides, and we're always looking to grow our expertise, both US and Latin America. And so I hope, Dan, that answers your question without being too coy about it. I could imagine though, that while physical offices aren't really the flavor of the month at the moment, some sort of virtual rollout in the coming months.
Thank you, Gary. Mauricio Gon Santos has raised his hand. Mauricio, do you have a question?
Yes, thank you, Luis. Congratulations to Gary, Sue, and Adriana for this very interesting and informative presentation. My question is regarding expedite procedure. So there are three possibilities. One is agreement of the parties, the monetary threshold, and the other one is exceptional circumstances or exceptional urgency. Urgency. And my question is who, when, and how to decide this exceptional urgency, and if there is any discussion later on regarding losing party to go and file vacatur proceedings or something along these lines.
Yeah, that's a great question. So let me try to, or set of questions. Let me try to answer them. First, it's the Court of Arbitration, the president, myself, and the vice presidents, as well as any committee of the court that we choose to constitute, that makes a decision whether or not to put a case into expedited procedure. Second, any one of those three criteria independently is sufficient to warrant expediting a case. You don't have to satisfy all three. You can satisfy any one of the three. Third, the fact that you satisfy one of those criteria, for example, it's a so-called small value dispute of, say, $1 million, doesn't guarantee that the case will be expedited. There's an element of discretion. If, for example, it's a small value case, but insanely complicated or even just a little bit complicated and thus not appropriate for a fast track procedure, the court would ordinarily not expedite it. The exceptional, or in fourth, the exceptional urgency limb or basis for expedition has been used quite infrequently. And if you think about it for a moment, I think you can see why. Typically, if there's a matter of exceptional urgency, you can deal with that both through emergency arbitration. On the one hand, we have a mechanism for that, or alternatively ask the tribunal to grant interim relief to deal with whatever the exceptional urgency is. The reason that we permit exceptional urgency, even in, at least hypothetically, a larger value case, is that there may be circumstances where a final award, not just an interim order of interim relief, is essential to resolving the parties' dispute fairly. You can imagine where, for example, there's a legislative requirement or a bid requirement that something be done within a specified time period, or some unrelated contractual requirement that mandates that something be done within a particular period of time, and that therefore it's essential that there be a decision, a final award within that time period. To my knowledge, we have not yet expedited a case based upon exceptional urgency. Naturally, if it's a large value case, we would want to ensure that the parties had a full opportunity to be heard and that there wouldn't be any complaints about procedure. But we do think it's important, and during our consultation process, users said they thought it was important to have this as a possibility. Note that all of these various limbs are subject to the fallback mechanism, the safety net that I referred to previously. If it turns out that the tribunal concludes it can't fairly resolve the matter in 6 months, then the time period can exceptionally be extended, and that does happen occasionally, only occasionally, but occasionally. We have not had challenges thus far, either in annulment or recognition proceedings to the fairness of an expedited procedure mechanism. You can certainly imagine applications of that sort. There's due process paranoia in all sorts of forms, but at least thus far, because we try to be careful about how we grant expedited procedure applications, and because hopefully we appoint high quality tribunals and arbitrators, we haven't had challenges thus far.
Thank you.
Thank you, Gary. Listen, time's moving along. I'd like to give the opportunity for one more question, if there is one, because we have a pretty busy agenda after this. Does anyone have another question? A tremendously modest group today. Again, I really appreciate Gary, SIAC, Adriana, for your time. It was an incredible presentation. There's no better way to restart membership meetings for MIAS than to have you. It's late, it's at least later where you're at than it is here. You're free to stay for if you're, there's a typical membership meeting, you'd be held hostage and you'd have to listen to our meeting. But you can stay if you're interested, but we understand it's later than usual. So if you can't stay, again, I appreciate very much the presentation.
Thank you so much, Louis. I hope this is a beginning, not an end. With our heightened U.S. presence and engagement, I hope we can look forward to future events like this, whether we're hostages or not. Thanks again.
Thank you.
Thank you.
Okay, thank you so much. Well, let's start with our the meeting. This has gone a little bit longer than I expected. So if I go into my Cuban mode and I start speaking quickly, you'll understand. I want to give a brief chairman's report. I want to devote some amount of time to the new website and the members profile that we're going to be doing. Later on, I want John to speak about the Arbitrators Committee. Harut will speak about Young MIAS. John will come back with the Rudy report. And if we have time, we'll go ahead and talk about finances. MIAS is I like to say zooming, so to speak, into the 21st century. We are going to change the way we reach out to our members and the way we reach out to the world. You can see just by my background that we've changed our logo. It's going to be a much more modern look to the to MIAS. And you're going to be noticing when I go through the website, you're going to see it's a far more dynamic page. It's nothing there's static. All members will have the ability to have their bios uploaded, and that will be visible. Not only can you upload it and will it be visible, it will be searchable. So if someone wants to go ahead and is looking for either an arbitrator or a counsel that has something, has experience in construction, they will be able to find it. If they are looking for someone with some type of language capability, it will be easily found. You're going to see we have made it easier to both join MIAS and to renew your membership. There's going to be an easy to use calendar. You're going to see our video library and whatnot. Before we go to that website, what have we done since the pandemic? We've had 4 webinars, something that MIAS has never had before. We used to have about 4 membership meetings a year. Well, this year, we had the one in January. We're having this one, and we'll see how we do in December, whether we have a membership meeting / holiday party. But we've also had 4 webinars, one with the ABA arbitrating during COVID. Another, we had an all-female panel talking about, Latin American arbitral institutions. We had another webinar dealing with protocols for online arbitrations, where 2 of our member firms, Hogan Lovells and DLA, went ahead and had their, they were part of the composition of these new protocols, and we had 2 associates from London go ahead and talk about these. And just a couple of weeks ago, we had, together with the University of Miami, a webinar on domestic sports arbitration. So I expect that's going to be continuing to happen. Young MIAS, and again, Harut will get to that later, but they had their first happy hour via Zoom. So things are moving pretty quickly here. But let's go ahead and let me see if I can share the screen and go through the website. And again, I'm going to try to do it quickly. Let's see, share screen. Hopefully I'm sharing the correct screen and you are seeing our website. And as I said, I'm going to try to do this quickly given the time. This is our landing page. And you can already tell that this is no longer a static screen. What we're trying to do here with the website is not just go ahead and say, we have great arbitrators or whatnot. We're selling Miami. And Miami is, as I said, they're multilingual. Miami is metropolitan. Miami, there's a cultural aspect to it. And you're going to see that. So throughout the website, we're going to be going ahead and promoting Miami as a venue. Then you're going to see up here on top, we have the general menu bar. Now, you will also see that the manner in which this website has been created is that there are multiple ways to get to someplace. So the first place you're going to go, if you don't know MIAS, you're going to go to the About MIAS section. And here we have a blurb about, what makes Miami a good place to arbitrate. You will also see here, and we'll get to this later, you can go ahead and see arbitrators. Okay, I decided to do it now. So you can go and see the arbitrators, the members of the group, support services and whatnot. Underneath here, you have a ticker. And this is going to be just the upcoming important arbitral events. So we have today's membership meeting, the 6th Annual Global Arbitration Review, the ICC meeting that's going to be held virtually should be there. If you want to go to the calendar, you can go here. If you want to see our webinars, you can go here. So again, there are multiple points of entry. The law firm members are going to be highlighted. There's a page that if you go there, you can see all the law firms. Not all the law firms have yet filed their, submitted their profile. So right now, if you just hit at any one of these, it'll go to the entire law firm page. At some point, if you hit Ackerman, it'll go straight to Ackerman. And then down here, the academic and arbitral institutions. If you hit the Learn More button, you're going to go to here, Arbitration in America. Arbitration in Miami. And what better way of selling yourself is have someone else.
As far as arbitration involving Latin American parties, one of the main arbitration hubs in the world, and rightly so. It has a solid arbitration community. It has solid court support. I think it has great infrastructures. And so the fact that the arbitration community here in Miami is continuing its effort to promote the city as an internet.
You get the idea. So we have Alexi Moore, singing the praises of Miami. You go here and we talk about Miami, and you have quality of hearing venues, arbitrators, the judiciary. And you can go ahead and contact to go to all of that. And at the end, we also talk about Miami art and culture. So you see that. If you go here to the next, you'll be able to see who our board of directors is. At the board of directors, you can see the mission statement. If you go to the board of directors, you can go and see Adolfo, or chair-elect. You can hit on him and you'll see his bio. And you can do that with anyone here, including our academic board members. We have a site for Young MIAS. Here is the banner that we used for the new Zoom cocktail. Again, this is going to be up to Young MIAS to populate to see how they want to use it. We have a site for the Arbitrators Committee. This is again, the Arbitrators Committee, and I give full credit to John Rooney. I think it's important to be selling the MIAS members as arbitrators. We're going to see how we're going to be doing that, and we'll listen a little bit to John. One of the things that you'll be noticing, we have these, you'll notice these panels, and you'll see on the, like in the landing page, and so you'll have the panels moving across. That will be kind of a signature for MIAS. And it makes what is an otherwise just typical picture something that you can easily recognize as being from MIAS. Then, okay, you already saw very briefly the page for individual members. So I'll show you the form that you're going to have to upload. And the first thing that comes up will be, this is how it's going to look. And then if you go into, and we'll take Dan's bio, and everyone will have this page. And so you'll see practice since '88, his arbitral experience, published articles. You have your firm bio, you have a PDF bio. If you have your bio in a different language, you can also upload that. So people will be able to go ahead and see each member in that fashion. Let's go back and see the law firms. And here again, similar, you'll have the logos for the different law firms. And then you go Hughes Hubbard. And if there's a brochure or bio, it goes here. This is their go ahead and description. The firm representatives. Nick hasn't filled in his profile page yet, so he's not here yet. But so all the members of the firm will be listed. Institutions and academic members. You heard how I mentioned to SIAC that they should become a member. Right now we have FIU and Miami Law. By the way, this is our web designer's favorite thing. You have this IBIS that will now go ahead and cross our logo. But this is somewhere where I'm hoping that we can get, let's say, the Latin American institutions, as well as SIAC, ICC, LCIA. They can all become members and get them involved with MIAS. And then finally, you can go here, and this will lead you to like the forthcoming events or the most recent events. And again, here you can see this panel situation. And then if you go to the events and then you hit on this, it'll come out and let you know what that's about. So there'll be a description as to that event. One of the most important features is this: find arbitrator and counsel. And you're going to see it's basically the same page that I showed you before, except that up here, you can go ahead and say select it. Right now, by the way, this does not yet work. It's very close to working. We're still, but it was important to get this out to you. So you can go ahead and do construction engineering, infrastructure and mining, years of experience, language, and then you can search members using those, those buttons. New way to join MIAS. Now, most of you have already joined MIAS, but but you need to see this anyway. First off, let me highlight this banner up here. If you look at this banner, it's taken from the M from our logo from Miami, and it's been kind of stylized and made with color, and something that we can use over and over again. There's 5 ways to join MIAS. You can have a law firm membership, an individual membership. You can have a student group membership, which would be free. A student membership, which is not almost free. I think it's $25. And here's the academic arbitral institutions. If you are a law firm and you want to first join, you click this, and it's going to tell you, well, are you a Florida firm or are you a non-resident? And here you enter, the firm contact, the firm name, your URL, and a whole host of questions that'll tell you what kind of, logo you can put in. Let's go back. If you are, and this is what I'm going to ask all of you to do, even though you're already a member, it's important for you to to populate your page. So you have an individual membership application and profile form. And here's where you're going to fill out your name, your email address, firm, that type of thing, photo, how long you've been practicing, your U.S. degrees, law school, bachelor, overseas degree, languages. Here's where you select, the industries you have experience in, the industries that you specialize in. If you're an arbitrator, how many times have you been chair? How many times have you been sole arbitrator, party counsel, co-arbitrator, emergency arbitrator? Do you practice in civil law jurisdictions, common law jurisdictions? Which ones? You can upload your PDF CV, not just your online one. If you have articles, you can put them here. When you go ahead and press submit, something's going to come out and basically say, well, if you've already paid, don't worry about this, but thank you for your submission. If you haven't paid, go ahead and it'll tell you to where you have to go ahead and pay. Now, something that's important to understand, you do not get to, once you submit it, you don't control your page after that. If you need to change it, you're going to have to submit it to our webmaster and she will go ahead and change it. So you have to make sure that when you put in this information, it's exactly what you want it to be and what you want it to say. Let me go now to renewing members. Once you've done that, and for the years, you're going to go and renew membership, and it's going to come here and tell you, well, what are you renewing? You're a law firm, and if you go there, by the way, it'll tell you how many of your law firm individuals are members. You get 3, but if you want to have 4 or 5, it will allow you to do that, and it'll give you a cost structure for that. If you're a non-resident law firm, if you're an academic or arbitral institution, you just go ahead and renew here. Again, individual lawyers, do it here, lawsuit student group. If you hit the membership with a renewal, but you really meant to join, well, that's fine. You go over here and it takes you back here. If you went to the join, but you really just have to renew, you can toggle back and forth to your heart's delight. Again, it's a very easy to use system. Let's go to the calendar. I think this is something that is going to be really worthwhile as we go ahead and populate this. You're going to have a calendar which you can view in this manner as a calendar, and you can go forward to or back, or you can also look at it in an agenda form and you can tell what's happening just without looking on the calendar. You can just see what are the next events. Again, if you want to see what our next events are, you just go ahead and hit here. Talking about our 2020 annual meeting, don't click there, it's not been decided. And of course, here are pictures from last year's event. Our news button. Here we have the Twitter feed for Kluwer Arbitration Blog and Law 360. It basically goes back about a week. So the most recent arbitration type information is there. But, and this is important because we need membership feedback. We're going to have, of course, the membership meeting, our webinars are going to be here. But if someone has an article and, MIAS members has an article and they want to repost it on the website, it can be posted here. This is not really a blog site, but it is something akin to that. And members, this can be a different way of disseminating exactly what MIAS members are doing. Let's go to our videos. Again, ever since the beginning of this year, we've kind of gone forward and started doing things online. This membership meeting will be online. And you go here and this page has our entire video libraries. You have our MIAS Minute, one which will be coming out next week or so. And you're going to be able to see the library there. The MIAS webinars are the interviews I'm having with different individuals. Here you have with Alexi Moore, the Rooney Report, and the membership meetings. And if you want to go and see Gabrielle Kaufman-Kohler again, that is there. You can also just go up here, and if you're just interested in saying, well, what was that webinar that we did, and you can just click on that and it'll just simply take you to the webinar page. So that is, easily done. Then we go to the final, we go Arbitration Resources. And this is something that I think is very user-friendly. First of all, I see Goel right there. Goel, you can, you can wave, I can see you. He's our student intern from the Miami Law LLM program, and he's been very helpful with us. So you go to the Arbitration Resources, and we have 8 boxes here: general legal guides, treaties and international instruments, rules and model clauses. You click into any one of these things, and what it'll do, it'll give you a list that will take you to other, other websites. These are obviously are not ours. It'll take you to other websites that you can go ahead and see. General legal guides. You can see all of that, Clue arbitration and whatnot. Databases, arbitration blogs. We have some of the, like we have the Hogan Lovells arbitration blog here, Global Arbitration News, which is the Baker McKenzie blog, Clue. You can just, again, this is, if you want, the concept is to make the MIAS website useful. In all candor, I was telling people that prior to this, I never went to the MIAS website. I want to make this something that if you have a question and you need a resource, let's see, you can go and get it, a place to go get it. Beneath this, we have national arbitral institutions and legislations for Latin America. So you go through and you have, again, listed, it's all self-explanatory. Canada, Chile, and you can go to whichever country and see if there's information there for you. Now, I'm going to show you this. Pretty soon, this will be kind of under construction, but this is something that is important that we go ahead and have, which is basically someone has an arbitration in Miami. I need audiovisual help. I need, where do I get photocopying, court reporters. And so you can go ahead and we're going to list all of these things here. If you are a member, Veritex is a member, you get to have, you'll be listed higher and you will have a MIAS membership button. You want court reporters, you just hit the toggle button here and it will just list the different court reporters. If you want to change that, you have to untoggle it and then go to, let's say, printing services. And then you'll go to the different printing services. What's here on the site currently, I fear, is not up to date. This is a work that was, we have been wanting to do this for a while. Some of this information was gathered, 3-4 years ago. So it may not be up to date, but I'm showing you what's coming down the road. And then finally, if you, we're going to have a similar thing for venues. Where do you want to go ahead and have your arbitration? And we're going to try to divide it up by size. Do you need a large, arbitration, medium, or whatnot? And then finally, we finalize when we come down here to the contact us. And here we have Inez, and you can go ahead and contact us. You can call her or whatnot. All of this, as you can tell, with pictures, the concept is to make this personable, make it accessible, and make people want, understand that at MIAS, we're professional, we're up to date, and as I said, accessible. This has been the dying tour of the website. Let me open it up to questions on the website before we go on to the rest of the program. Anyone have questions? Paul.
Yeah, good morning, everyone. Good to see all of you, albeit virtually, as was said. I'm very impressed with the tour of the website. I'm like Luis, I had never really visited the old one a whole lot, and I think I would be visiting this one a lot more. Is it possible to add, I don't know if it's already there, Luis, some points in plugging the excellent internet connections in Miami? You know, we may not always go back to the old model of physical presence for all these hearings and things. And some of them, at least certain preliminary matters, will probably be done on Zoom like this one. And therefore, Miami being the Napa, the America's entry point and consequent reliable internet and other things related to virtual hearings might be added.
Well, I appreciate that, Paul. No, I don't think there's anything really on that, but that brings up a great point. Look at the website. The website's up. You know, it's not perfect. By the way, I'm not sure if I mentioned this. It doesn't really translate currently well to your smartphone. That takes time. You know, you have to go page by page and format it to make sure that it translates there. But I think, Paul, if you can write me and Inez an email with your suggestions, criticisms, how to improve it. This is still a work in progress, although it's, as you can tell, far along. We would all appreciate it if you see something that's wrong. Tell us. It's important.
Thanks, Luis. I confess I need to visit it first. This is my first visit, just on your tour, like a tourist, you know. So let me do that in the coming, time. And then if I have any, maybe you already have a lot of this stuff. So let me have a look, and I'll be sure to write you.
No, that's very important. It's we just learn a lot from everyone. Any other questions?
Yes, Luis. Hi, it's Giselle. Congratulations. You did a fantastic job. I am like you. I didn't go to the old MIAS site, but I am very impressed. It's hours and hours of work. And I just want to congratulate you and Ines and everybody on the board, and Noel and the intern, everybody working. You all did a terrific job. I have one comment and two questions. It may be there, Luis, because I haven't seen the site. I think the part about Miami, if we put something about the airport and the accessibility, how many hours from New York, how many hours from London, the airport and the ease of getting the taxi and just quickly, because we have a terrific international airport in Miami as well as Fort Lauderdale, that might be another bonus for people coming from other jurisdictions. My two questions are, one, you mentioned on the contact us for Ines, it says, invite me to the MIAS newsletter. If you're a member, do you automatically get the newsletter, or if we pay dues, do we need to sign up again to get the newsletter?
No, I don't think so. I think whatever e-briefs and things like that, if you're a member, you already get it.
Okay. And my second question was, as you were showing us through the pages, which was very helpful, you clicked on a page. I know we didn't have time to see everything, and I'll look after. It said case database with links to arbitral databases. Can you tell us what that is, please?
Sure. Let's just go there. So, and we can see it. So we go to the case database, and I was noticing like Clout is over here, and I think it should be over here, but so you go to the case database, and so you can go to the investment arbitrator, IT law, here. Here you have the if you're looking for SIAC, you can go ahead and see it. So again, this is another place where the membership, you use different resources, tell us and see what should be put on here.
Awesome. Thank you so much, Luis. That was very helpful. Thank you. Congratulations.
And by the way, despite the fact that I really want to take all the credit because, don't we all? The truth is a lot of work, this was done with MIAS creatives, Katja MIAS. If any of you have gone to the Mark Migdal and Hayden website, she did that site. Don Hayden suggested. I worked, I and Inez have been meeting with her weekly and for the past week daily for many months now. So she gets a lot, she really gets the lion's share. This was built, some of the limitations we had, it was built on the platform that we had before, which is the Wix platform, but I think you can tell that we did a lot with it. Any other, one or two more questions so that we can get through the rest of the.
Luis, this is Sherman, and congratulations to everyone who put their time into this. And in addition to being just visually very impressive, it's also seems to be a great resource for the community here. Love how you have an area for articles or updates. Who would those updates go to if someone has something that might be a candidate for sharing on that part of the website? Should those go to Inez or?
Yeah, you would send it to Inez, and ultimately she would funnel it to the webmaster or whatever it's called, and they would put it up. Absolutely. Any other questions? Okay, with that, I recommend that you all go to the Join MIAS page. If you paid, don't worry about it, but go out and fill out your form. If you are a law firm, fill out the law firm membership, and then fill out the individual membership for the individual members who are also the part. So let's move on from here, but I certainly hope that you appreciate the efforts that we went into that. I think it's going to make a big difference in the way MIAS is perceived in the future. By the way, one of the ideas that Adolfo had, and I think it might be very good, is once we really have it, we might have monthly promoting a particular member, and trying to go out and say, what is this member or what is this law firm doing, and trying to promote our members that way. So, so let's now go ahead, and I think we have a couple of presentations. One would be Young MIAS. Harut, let me turn to you.
Yeah, thank you so much, Luis. And if there's a little bit of background noise, I apologize. But as you know, one of our key initiatives for this year has been the Young MIAS team, building that up and developing it within sort of our community. This has been something that has been talked about for some time and has been a project of yours in your term as chair. We successfully launched Young MIAS this year and have built up our social media presence by incorporating the Future of Arbitration Miami's social media presence. That's happened already. If those of you who are not already following us on social media, please go ahead and do that. We encourage you to do that. And we have over 100 members already on Facebook. So if you are not already following us, please do. And of course, as you mentioned, on September 16th, we had a terrific first program, a happy hour that featured a number of people from throughout the world. I think, as you mentioned at our board meeting as well yesterday, I had the good fortune of being involved in that, and I know you were there as well. We had dozens of people who are, our initial members. We've assembled a board or an advisory committee of people who are at the various firms in our community and at the universities and elsewhere, who are going to be a part of building this up and developing it in the coming year as well. So we've gone a long way in several months in putting down the foundation. We've already had an event. We have a social media presence. Join if you haven't yet. and we look forward to hosting more events in the near future. Happy to answer questions from anyone. But of course, I would be remiss, Jessica Marroquin would be making this presentation, but unfortunately is not available to participate today. So I should really give her the credit. My role is just the board of directors representative to this in this effort. But Jessica has done a fantastic job and really should be commended by our membership as well as the board for the excellent work that she's done.
Any questions for Harut? Okay, well then let's go to John, who has two reports. And just for sake of being able to edit this video, let's first start with the Arbitrator Committee's report, which, as I said, really was your idea, and I think it was a great idea. You had tremendous plans for that this year, which, for some unknown reason, did not come to fruition. Why don't you talk to you about your vision for the Arbitrators Committee?
Absolutely. In part, it's because, and I'm sure some of you have experienced this as well, for some reason, COVID has either resulted or permitted a kind of an explosion of work. And I do work by myself, and luckily I've been actually very busy these past couple of months. But there were a couple of other things that I did want to mention. First, Tiffany, who I believe is on the call. I am planning on recruiting her to be right by me with respect to the development of the committee. And we've been trying to get together, and mostly because of problems with my schedule, we've not been able to do so. Some of the other things that I've been thinking of actually have been incorporated into the website, one of which was the creation of like a directory of arbitrators. That is, I think, appropriately in the website, and we're not going to reinvent the wheel and do that again. And there was there's another development that I really can't talk about yet because it's still in gestation, which is the possibility of MIAS, and in particular the Arbitrator Committee, participating in an arbitrator training program, which would be sponsored by a regional organization. But the plans have not yet solidified, so I can't really mention it yet. But what it would involve basically would be members of the committee participating as faculty and as facilitators for persons who are looking for credentialing as arbitrators in the region. Hopefully by the next meeting, we'll be able to have an announcement with respect to that. If anybody,
would that be done something like a version of the Chartered Institute?
It would probably have some similarities, but it would have a more regional focus to it, I would say. And I would anticipate that most of the instruction would probably be in Spanish as well. So it would be kind of similar in a sense. And the other thing is, what I envision actually for the committee is a place for arbitrators to get together and to discuss the kinds of issues and problems and solutions that we come up with in terms of managing arbitrations. One of the great advantages I thought of the Chartered Institute training program was the fact that arbitrators actually sat down. We all go to conferences and we all have different interests, but this was concentrated specifically on arbitrators, and a lot of the breakout sessions rather provided almost a unique opportunity to just talk to arbitrators with respect to issues that come up. And to a certain extent, I'm looking to replicate that for us in MIAS. If you like, I can just.
Well, one other thing, you had an idea earlier in the year, and this is what went by the wayside, but I think whenever things come back to normal, the concept of going and visiting the arbitral institutions, taking arbitrators, why don't you talk about that? Because I thought that was a great idea, and it's something that, again, given the current situation, was not able to be done.
One of the things that I noticed many years ago, I was actually a counsel in an ICDR arbitration, and the tribunal were 3 arbitrators from New York, and I noticed that the institution actually reached out to them in an obvious way, which was fine, to basically say that they would take them around and they would introduce them, for example, to the case managers and everyone. I think a kind of roadshow for us would be I think, warmly accepted by most institutions. We can go to New York and probably hit 3 or 4 of them at once, for example. And the idea would basically be for the people who make the selection of arbitrators to connect a face with a name and to get a feel for the person, because so much of what makes one, I think, effective as an arbitrator, especially in a tribunal, is the thing that you don't see on the resume, which is basically can you play well with others? What kind of human chemistry will you have with the other members of the committee and of the tribunal? And those kinds of things can be picked up, I think, more by an in-person meeting. But once again, that will have to wait probably till next year. I would hope by next year we could do that. And also, if there's anyone on the call in the meeting here, I know some of you have responded already with interest about the committee, but if there's anyone else who has interest in the committee, please feel free to, I think you can just contact Inez and she can put you in touch with me, or you can contact me. My email is very easy, rooneyjh@gmail.com.
Thank you. Okay, now we can lead into the famous, if not rare, Rooney report.
Yes, rare. And since it follows up at the end, as I told Louis, it's one of the only rules of chemistry that I can remember, and I was really a terrible student in chemistry, was that a gas will expand to fill the size of the container that it's placed in. So we're at the end of this. This will not take very long. What I'm going to do is just mention basically 3, possibly 4 important judicial developments. I will just go ahead, since we now have a space on the website, I will put links to the original decisions. Many of these you know about already, some of which perhaps not. But I will just very, very briefly give you kind of a 30,000 feet description. Of course, we have the GE Energy Power decision of the Supreme Court in June 1st of this year, which is really one of the few times, amazingly, that the Supreme Court has actually dealt with a New York Convention issue by getting into the weeds and analyzing the application of the applicable articles and subarticles of the convention. In this particular case, it was relatively easy to state what was going on. A non-party, under principles of equitable estoppel, wanted to require a party in an arbitration agreement to submit to arbitration. The 11th Circuit basically said you need an agreement in writing under Article 2.2. You didn't have one, you can't do it, and created actually a dichotomy between domestic and international arbitration, where you could do it domestically, you could not do it internationally. In a nutshell, at least by my reading, what the Supreme Court did is it basically said that, look, in this particular case, it's true GE Energy Power didn't sign the agreement, but there was a signed arbitration agreement. So the signed arbitration agreement didn't have to be between the parties who were trying to compel arbitration under Article 2, Section 3, and basically said you would look to state law principles of equitable estoppel to see if in fact that would happen. And I think that was basically the gist of the decision. There's a lot more in there. It's not very long, but I think it's well worth looking over. Another recent decision is the Servotronics decision out of the 7th Circuit rather, where the 7th Circuit unfortunately decided that a private international commercial arbitration was not a foreign or international tribunal for the purposes of 28 USC 1782. That will just put that on the website. It's actually comes right out and says it in the first paragraph, and it is worth reading, I think, in terms of its analysis and discussion. There's two recent developments actually from across the pond that I think would be worthwhile looking at. One is on October the 9th, the UK Supreme Court issued its judgment in Enka Insat versus what we're just going to call Chubb, Russia. There are a lot more names and words involved. It basically involved a situation in which the court was called on to determine what would be the appropriate law to apply to an arbitration agreement. In this particular case, the court concluded that the container agreement, neither the arbitration agreement nor the container agreement, contained a choice of law clause, even though it was very likely applying European Union principles, which are not applicable to arbitration, that the container agreement was governed by Russian law. The court concluded that the arbitration agreement, because the arbitration was cited in England, and England had the closest connection to the dispute, would in fact be the law applicable to the arbitration agreement. The judgment goes on for well over 100 pages. It doesn't just talk about that. It talks about pretty much every aspect of English arbitration law you can imagine in terms of determining what the law applicable to the arbitration agreement would be. But it also would serve obviously as a good guide if you were looking at the law of another jurisdiction to be sure that you're covering everything and perhaps looking at some other ideas that might occur to you as a result of reading that. And let me see, there was one other. This is an older case. This was actually a judgment of the English High Court on appeal, January 20th, 2020. Khabib G. SAL versus Cloud Food Group. And I'll just say, I'm going to put it on the web for you to look at. It's a fascinating discussion of how you determine the relationship of the container agreement to the arbitration agreement under English law to determine whether or not non-signatories could be bound to the arbitration agreement. It's a long discussion. The clause is actually probably an example of how not to write an arbitration clause. It involves the unidroit principles, it involves English law, it involves everything you can possibly imagine. And the court had a tough task ahead of it. And it is a very, very thorough explanation of how they reached their conclusion. So those four items will be placed in the Rooney report section of the website so that you can download them if you want them. And the other thing I would mention is that the LCIA has come out with 2020 revisions to their rules. That basically.
Collins has raised his hand a couple of times, I believe,
Uh-huh.
virtually. Ed, do you have a question?
No, I just wanted to point out that those that may not remember that for the Supreme Court case, MIAS actually was an amici.
Yes.
Although you can't find that when you look at the published decision, unfortunately. They were not
Really?
listed. Well, you were.
Wow, that's a shame they didn't list it. Absolutely.
They didn't list us. They didn't list us, but that was our second amicus, our first Supreme Court one. Yes.
Well,
obviously, it didn't make an impression on you either. So
I knew that.
Ed, that's a great point, and that's something that you should write in. We should have a place for the amicus committee on the website, and all our amicus should be listed there. If you could write that in, and so that would be something else to be added to the website.
Listen, we also have an announcement with the chair's discretion.
Well, okay. I was about to say we've been here an hour 40, which I think is pretty good given we had an extensive presentation to begin with. I was going to go down the list and give everyone 15 to 20 seconds opportunity to announce themselves and anything that they want to tell the group. It's kind of what we used to do around the table. I'm not about to hit the mute button as in a presidential debate, but I do ask that everyone understand that there's currently 36 people at 30 seconds each. That would be 18 minutes. We would like to keep it less. But Ed, since you wanted to say something, you can start that off, and then after that, I'm just basically going to go down the list of participants that I have here and call you out. And if you just want to say hi, just say hi. If you have something to say, please, let the group know. So Ed, you get to kick it off.
Yeah, sure. It's Ed Mullins, Reed Smith. A lot of people on this call are involved in a program we're doing for the ABA International It's going to be a mock arbitration that we're doing that Dan Gonzalez and William Hill are taking point on. But if you're interested in that, Dan can provide you details, but I just wanted to raise it if anybody's interested in that. Thank you very much.
And Ed, that brings a great point. To the extent something like that is going on, you have to, and everyone else, let us know so we can put it on the calendar. Let's just go down. Joan Stearns. Joan, I see you are here. Can you introduce yourself?
Hi, Joan Stearns Johnson, University of Florida. Nice to see everyone. I won't take up much time. We are looking for arbitrators to serve judges for a student competition for November 6th, primarily. If you don't mind shooting me an email at johnson@law.ufl.edu, Johnson with an E. Could use some help. Thanks so much. Thanks for the opportunity. The website looks fabulous.
Thank you, Joan. And I ask that Inez go ahead and send out to the entire membership your request for arbitrators to see what you can find out. Okay, after that, Adrian Nunez. Adrian, you're on mute.
All right. Can you hear me now?
Now we can hear you.
Oh, okay. Just wanted to say, Luis, thank you, and thank you for everybody. Great presentation today, and I love the website and what it's doing. So that's fabulous. Looking forward to help out Harut and everybody with Young MIAS, and also wanted to say that I'm chairing again the Vis Pre-Moot with Florida Bar International Law Section. So if we have a lot of people here, if anybody wants to participate, we're going to be doing a call for arbitrators, and we're going to be doing a virtual pre-moot. So it'll be exciting, something new for us, and hopefully it'll be convenient for everybody to participate, including the law schools. So, but again, don't want to take up too much of your time, and great presentation today.
Thanks, Adrian. And if you want us to send out a notice to the group again, ask Inez. Alvin Lindsay.
Hey, Al Lindsay. Thanks, Luis. Great job. Website, everything. You've done a lot of really great work during your term. Thank you.
Okay. I love that shortness and to the point. Plus, your words of wisdom about me. Thank you. Anna Tuponski, and I don't want to kill your last name, Tuponski.
Hi, Liz. Hello, everybody. Great work on the website. Glad to see MIAS evolve and grow. And I hope to see everybody soon in person and not virtually.
Okay. Carlos Romero. And Carlos, again, say where you work and things like this so that everyone is up, even everyone knows you. It's good that everyone everyone follow that procedure. Carlos? Well, he's we'll come back to him if he comes back to the group. Carolina Barrio.
Hello, good morning, everyone. I congratulate you. It's awesome. The webpage is, I know what is difficult to prepare a webpage because as I've been the Secretary General of the IABA, I have to do it. So it's incredible. And I'm looking forward for our development in Miami arbitration. And I want to invite you to organize a seminar in the mandatory bar in Buenos Aires City, as I'm licensed there, and I be part of the governors there. I have already told them, so I was going to tell you to offer this before, maybe we can do it in December, to promote the arbitration, Miami arbitration in Buenos Aires City. Thank you.
Again, like everything else, send your request to Inez and we'll try to disseminate and do what we can.
Okay, thank you.
Okay. Delmrod Statvadles. Yeah. Okay. Yeah. Okay. I'm not too good with the Slavic names. Do you want to go ahead and introduce yourself?
Hi, how are you doing?
Good.
My name is Dilmurat. I come from Uzbekistan. It's in Central Asia. I'm doing a joint LLM and JD degree at the University of Miami. I frequently attend the events of the MIAS. I'm really interested in in working in international arbitration. Previously, I worked for the government of Uzbekistan and represented the government in some investment arbitration cases. That led me, that motivated me basically to come to Miami, do the International Arbitration LLM program at the University of Miami. But then I decided to transfer to JD to be admitted in Florida, as Florida bar requires to have that JD. So I'm graduating this December, taking the bar in February, and hoping to work in the field that I want, which is international arbitration. Long story short, thank you.
Thank you so much. Giselle Leonardo.
Hi, everybody. Giselle Leonardo. I'm an independent arbitrator. I am an engineer and I specialize in engineering, construction, and energy international arbitrations. Thank you so much. Everyone's doing a great job. Thank you.
Goel, it's your turn.
Hi, good morning, everyone, and good night. I'm Goel. I'm an LLM student at the University of Miami, and I'm also helping to coach the Visnute team for the university. And it's a pleasure to be working with Professor Naughton and also Professor Rooney with the MIAS and seeing how everything's coming together.
Yes, and as I mentioned before, Goel has been helping us with the website. He kind of, has a practicum with MIAS, and so he's been great, and it's really been of great assistance. Going down, the next person is Judy. Judy, maybe you can give a more than a 30-second account of the Untitled working group and MIAS's presentation there.
Thank you, Luis. As many of you know, MIAS has been an active participant in Working Group 2 on arbitration and conciliation, now mediation, and for a number of years has been represented there. But most recently, it has been represented very actively by a task force that has been contributing memoranda with suggestions as to how to draft a set of expedited arbitration rules for an ad hoc arbitration, something that presents challenges because without an institution backing up the rules, you have to create circumstances where decisions can be made that otherwise would normally be made by an arbitral institution. For example, you heard earlier about SIAC and the standards they have for deciding whether or not a case qualifies for an expedited arbitration. Just very briefly, if you don't have an institution making those decisions, you have to craft something else. Ultimately, in this particular framework, although it was suggested, for example, to have a financial threshold, UNCITRAL does not deal, being a United Nations organization, does not deal with any one particular currency. Therefore, you couldn't, for example, suggest a Singapore dollar or a US dollar threshold. So the ultimate decision was, if the parties decide that's what they want, if it's a party agreement, that's what they get. With that, just as a little detail regarding that, I'd like to give a shout out to John Barquette, who has been the author and the moving force behind the task force and putting together a document that has been presented now 3 times at the UNCITRAL proceedings in Vienna and in New York. Most recently in Vienna virtually, although apparently 5 people actually did show up in Vienna out of the usual 100, maybe 150 participants. The rest were virtual. And again, another shout out to John Barquette, because not only did he participate by presenting this paper, he participated by being active starting at 5 o'clock in the morning when the meeting started, because they were starting at 11 o'clock Vienna time. After that, I'd just like to ask everyone who's on and who is interested in the MIAS programs, if there are topics that you would like to see being handled, please let us know. We're putting together the program for next year. It's all still a long list of very desirable suggestions. But if there are areas that you would like to have covered, let us know and we'll see if we can accommodate you with a program. And if you're really interested and happen to be an expert in that field, we might even draft you to be part of the program. Thank you.
Thanks, Judy. And let me echo what she says about John Barquette. First of all, and that's something else that, by the way, should be on the website. You know, the work he's done and the papers that he submitted on that on MIAS's behalf are really excellent. And in fact, as I understand it, nothing compares. There's been no other non-governmental group or anything like this that has presented something as thorough as what MIAS has done. So again, we're all appreciative of John's efforts, but also yours, Judy. So thanks so much. Let's try to go through this quickly. Kristen Pass.
Hi, everyone. Great to see you. I am a partner at Schutt & Bowen. I'm representing, I think, the only one here today at the firm. And great website, great presentation.
Thank you so much, Kristen. Maria Clara Moreno.
Hi, I'm Maria Clara Moreno. I'm licensed in Colombia and Florida. And I actually got interested in arbitration because of the Mood Madrid, which Luis was a great mentor to me. And I'm happy to be a part of MIAS.
Thank you, Maria Clara. Maria Gomez.
Hi, everyone. Good morning. My name is Maria Gomez. I'm originally from Spain, and I'm on my last semester at UM doing the JD and LLM program. And I just wanted to thank you for giving us the opportunity to students and job practitioners to join the association, and very much looking forward to joining next events and meetings.
Thank you, Maria. Mauricio, you already spoke, but I'll give you a chance to say hi again. Mauricio Gonzalez.
Okay, good morning. My name is Mauricio Gom. I am an international arbitrator with GST, a Brazilian lawyer, New York lawyer, and Florida foreign legal consultant. A very exotic package. Thank you.
Exotic, but both friendly and an excellent arbitrator and a good friend. So thanks, Mauricio, for all your help.
Thank you.
Nick from New York, Nick Swerdloff.
Hi, Louis. Hi, everyone. Nick Swerdloff, Lewis's partner at Hughes Hubbard, ensconced in my bunker. And I'm happy to see you all, at least virtually, and certainly look forward to seeing you guys in real life whenever we emerge from this crazy thing. Good job today, Louis.
Thanks, Nick. Hopefully you'll be down in Miami sometime in the foreseeable future.
As soon as I get my travel papers.
Oscar Cabañas.
Hi, my name's Oscar Cabañas. I'm the 2L at Nova Southeastern. This is actually my first MIAS meeting. I'm very glad to be a part of this and to start my journey now with all of you. I'm looking forward to getting to meet all of you in person, although meeting you all virtually is just as nice. So thank you so much. The website looks amazing and I'm excited. Thank you.
Well, remember to join. Thank you so much. Great to have you. Paul, you get to say hi again too.
Good morning, everyone. I'm Paul Mason. I'm an independent arbitrator and mediator, mostly international cases from Latin America, Asia, some Europe. It's a great pleasure to see everyone, and also a great pleasure, I might add. It was a great meeting and great job by Luis on the website and by John on his activities. I must say, that it is a unique pleasure really to see this organization grow like a child and become so mature and so active since early 2000s when Burton Landy and I first discussed the idea of starting this Bankers Club downtown. It's really grown in a fantastic way. Congratulations to everyone.
Well, well, Paul, I used to be a kid. I now have gray beard like you, as MIAS has grown. So yes, thank you so much. Thanks for all your help and always being there. Sherman, you get to say hi again too. Sherman, are you still there? Okay, he may not be. Tom Snook?
Sherman was
I would say I'm actually not in New York Harbor, but I was when that photograph was taken. I was stationed as a district legal officer in New York, retired Coast Guard JAG officer, solo practitioner, emphasizing maritime law, international law, but mainly hunkered down, trying to build a garage next to my house in Coral Gables, which takes forever. Thank you very much.
Well, no, thank you for joining. Love the tall ship. And last on my list right now is Yesenia Alfonso.
Hi, good morning, everyone. I apologize I can't be on video today. I will be next time, but this is actually my first MIAS meeting. I'm an international arbitration student in the ELM program at Miami Law. And before this, I've studied law at Queen Mary, and I'm actually a Miami native. So I studied at FIU. I studied international relations there, which is sort of what got me into international arbitration. I'd just like to say that the website looks amazing, and I'd like to congratulate everyone who worked on it, because as a student, I can definitely appreciate having one place to have all these resources that you need at so many different times. And I'm just excited to be a part of the group and to hopefully contribute to MIAS in the future. So thank you so much.
Thank you, Yesenia. And I fibbed. But for some reason, Tiffany got moved on my list, so I missed her. Tiffany, you're on this. And plus, you made a move, so you should talk about your move.
That's right. That's right. So those of you who know me know I was a partner at Schutz & Bowen, and I've moved to Fisher Broyles. I'm thrilled with the move. I moved in May. I am really growing the team over there. So we've been adding people and the international disputes team. And so I continue to serve as a counselor, representing clients in international arbitration actions. But I've also been increasing my work as an arbitrator, working in English and Spanish and in French with the ICC and other institutions. And I'm very excited to be working with John Rooney on the new Arbitrators Committee for MIAS.
Thank you. Amazingly enough, we started today, we went up to like 42, 43 people. After 2 hours, we still have 25 people as participants. Did I miss anyone that I did not call out to introduce themselves? Apparently not. Again, so let's bring this. Ishan, I was planning on calling you, and then for some reason your name moved around. Ishan, great background. It's the wrong city, but that's okay. We'll forgive you. Talk to us what you've been doing at Arbitral.
So good morning, everyone. It's been a long morning, but I must say it's been a fantastic morning. As you can see, Arbitral, this is what I've been working on of late, developing understanding and expanding thought leadership on the interplay between international arbitration and insolvency, something that the world is going to tackle a lot in a year or two to come. I've been writing a lot. Fortunately, I've had the blessing of Professor John Rooney, who's been guiding me on a lot of writings and research in this field. And I've been conducting a lot of webinars from experts around the world. We've had some great successes, and I really look forward to conducting something with MIAS on the field, especially with a focus on Latin America. And again, a big congratulations on this event with SIAC today. SIAC and a lot of people back there in the East believe a lot in East meets West. And I think there can be nothing better than Miami to give a great representation of the region. And I will be organizing some events within Asia Focus as well. And I think it would be great to have Miami and MIAS be involved in those efforts. And again, last but not least, hats off to Professor Ronatin for doing great things in this most challenging year. And I was just texting him, and I will reiterate it on screen that the website and everything that we saw today has redefined the MIAS experience. So congratulations.
Thank you. Anyone that knows me knows that compliments are most welcome. You know, just keep them coming. You know, there's no problem about that. So they're all accepted. Thank you so much. Listen, it's been 2 hours. It's been a little bit longer than usual, but I think it's been the first membership meeting in a while, and I think we had a bunch to talk about. Please do go in, do sign up. Please do go in, look at the website, and send us your comments. You know, this is a work in progress. A work in progress that should never end. It should always be improved. It should always be made better. But for that, we need your help. And with that, again, I bid you a good morning, good evening to those across the pond if they're still around. And thank you so much to everyone for joining. Ciao.